Thank you, Mr. Chairman. Professor Turley, I'd like to start with you, if that's okay. You recently wrote about the cases of two attorneys, Collinford Mattis and Aruj Rahman. Each of these two defendants was facing domestic terrorism charges based on allegations that they had thrown a Molotov cocktail into a police vehicle during the Antifa riots during the summer of 2020. Despite pleading guilty last year to one count of possessing and making an explosive device, which, as I understood it, should have carried with it a 10-year minimum sentence, the Biden administration, if I understand it correctly, has just agreed to a new plea agreement that will result in just a few years of prison time. Professor Turley, are violent attacks on police officers with explosive devices under this circumstance, are they domestic terrorism events, or are they domestic terror threats?
Well, they certainly can be under the definition that you have at 18 U.S.C. 2331. It can fit into that. You know, there are arguments to be made why they decided to downgrade that case from terrorism, and the plea that you referred to didn't receive a huge amount of condemnation because it was still, as you noted, a plea to an offense that was a 10-year offense. It's to keep in mind, one of these individuals was trying to hand out Molotov cocktails for other people to throw them, and the other one, when she was arrested, said that it was unapologetic and said that they only understand violence when we speak through violence. So these were quite strong cases. They were captured on videotape. So it was surprising when the Department of Justice came in and said, we're going to let you withdraw the earlier plea and then plea down. And as a criminal defense attorney, I thought it was really quite astonishing. I've done national security litigation. I haven't seen anything quite like that double step down with to remove the earlier plea. So I think it was very controversial. And I'm saying that I want to emphasize that I think people of good faith can say that the original designation of the case is terrorism. I can see arguments that this should not fall within that definition. People of good faith can disagree on that. It was the step down from the original plea that was so astonishing for some of us.
Okay. One of the things that I worry about with all of this is that anytime there is an act of domestic terrorism, it should be prosecuted. Domestic terrorism is bad, regardless of what ideology happens to flow from it. And one of the concerns that I've heard expressed about the Domestic Terrorism Prevention Act, concerns that have been attributed to Department of Justice career attorneys in reviewing the legislation, is they worry that this could artificially constrain the department's resources, directing them toward one particular ideology over another. With domestic terrorism, as in so many other areas of criminal law, there is a high likelihood that what's big one year might change the next year. What's happening a lot in one season of one year might change in the next season of that same year. So my concern would be if we start adopting legislation that directs our activities, devotes more resources to one particular ideology over another, that might leave prosecutors flat-footed when the circumstances change, and that could create other problems. Now, Mr. Herdman, what would be the practical result, in your view, of various executive office reorganizations that would be required within the Department of Justice under the Domestic Terrorism Prevention Act?
Well, I think, you know, one concern that I would have is from the perspective of, say, a rabbi in suburban Cleveland, whether the threat to my synagogue is from a white supremacist or it's from a violent jihadist or it's from some other group, that doesn't matter to me as much as the fact that there is a threat that's existent, and federal law enforcement has to be able to respond to the threat to that particular target. So I would worry a little bit about escalating or elevating a particular threat profile because you may unintentionally lose sight of other threats. I think it's better to have a flexible federal law enforcement response, Senator.
And while I've got you on this point, I wanted to ask you about something that in the aftermath of the extensive violence that occurred in the summer of 2020, particularly in Portland, Oregon, federal prosecutors brought actions. They brought federal charges against 97 defendants. Now, there were other defendants who were charged in connection with those riots, many of them in state court. These 97 were just the federal charges brought in that district. 58 of those 97 have now been dismissed. Now, I know you're a former U.S. attorney. When I was a federal prosecutor, it would have been unusual to dismiss such a large percentage of any category of indictments that had previously been issued. But if 58 of those 97 have now been dismissed, it has me scratching my head. You have any idea why these cases against those particular violent extremists were dismissed in such high numbers?
I really don't know enough about those cases, Senator, to be able to reflect on it. The only thing I would say is, what our guideposts were when we were federal prosecutors was, do the facts fit a violation of a federal statute? And if they do, you pursue prosecution. And I don't know if that's what happened in the case of those dismissals or not. I just don't know enough about it.
Thank you.
Thank you, Senator Lee. Senator Whitehouse.
Thank you, Chairman, and welcome to the witnesses, particularly Mr. Whitfield at 86. Your